Talk. Welcome back. Home of common sense. 0344 499 1000. Now, the story of the 3 teenage travellers' sentences for rape of 2 schoolgirls has been referred to the Court of Appeal after a decision to spare them jail sparked outrage. The 2 girls, aged 14 and 15 at the time, were raped by 2 14-year-old boys weeks apart in Hampshire, with a then 13-year-old also convicted over his role in the second incident. All 3 were handed youth rehabilitation orders and walked free from court. And what some people found upsetting were also the judge's comments on this. Let's get a word from Chris Dorr, KC, barrister, writer and broadcaster, good friend of the show. Morning to you, Chris. Not unusual we see people fall out with the decision of a judge. You know, I get that. It's a democracy. This one has caught the eye of the Prime Minister, however, seems to have gone right to the top. How do you see this particular case as distinct from others of a similar nature?
Well, I see it in the same ways that I see any case that I haven't read the files for and haven't seen the evidence for and have only read a few hundred words of headlines and reports in newspapers and online. And I suspect that's all the Prime Minister had seen when he decided to wade into it, because let's be honest, he waded into it even though it was nothing to do with him. The decision whether to refer a case like this to the Court of Appeal is for the Attorney General, and the Attorney General has to do it on very strict legal grounds, although how that was done in a few days is difficult to imagine.
I mean, there's no doubt that Starmer did jump on, and some would say maybe it's his job as a Prime Minister to reflect what appears to be some growing anger at what is by any stretch of the imagination, let's be polite, a curious sentence for the crime of rape. I did see that this particular, and you're right, the details of the judge's words, which are public, but it's snail's pace stuff, as you know, in the legal world to find it. So it's not secret. It just hasn't, I think, been uploaded to the relevant websites yet. But I did hear, and I was reading that if this had been adults being tried for this case with all of the details considered, then the defendants would have been looking at between 12 and 19 years in jail, which takes it to the sort of higher end of this kind of sexual assault rape case.
Oh, absolutely. Of course, you're right. And that's the way that youth sentencing, or child sentencing, as I call it, works. Child sentencing is focused on the welfare of children. It's not focused on punishing and locking people up for as long as possible. And that's quite right. It's a very different position when you're dealing with, for example, a 40-year-old adult child sex offender who's been committing child sex offences for decades, who finds himself convicted of something like this. Of course, he's going to receive a very long sentence, if not a life sentence. But of course, we don't treat children the way we do adults, except it seems in the criminal justice system, because we certainly don't let them vote on the criminal law.
Well, we don't. But it does seem, Chris, and just looking at this, that to not get some kind of custodial sentence, and I think the quote that we have got from the judge is that you don't belong in prison. And I know you have your own criticisms about how we over-prison people in this country, but I mean, if you can't go to jail for an offence as brutal and horrific as this, then what can you go to prison for?
Well, you say you can't go to jail. What you're talking about is children can't go to jail, 13 and 14.
Well, it's not jail, is it? It will be a youth custody of some kind, but it's not prison. It's not Strangeways.
Where do you think they're going to go? Because what happens to teenagers is they go to something called a young offenders institution, and a young offenders institution is a prison. I've been to many of them. They're just prisons. They have bars, they have clanging gates and all the other stuff. Okay, as a society, we can say, yeah, we want to send children to prison. In fact, we used to hang children in the Victorian times. So why don't we go back to that?
Well, no one's saying hang anybody. I mean, that takes it to another level. But a custodial sentence for rape would seem to be a default position, right? I mean, that would be unlikely that any other consideration would take place. I mean, what could be the mitigating circumstances that would stop you being incarcerated for a crime of this magnitude?
Well, the judge, I think, explained that. And even the public reports about that made clear that these children who committed these crimes were, in many cases, intellectually operating at well below their own level and emotionally operating at below their chronological age, which, of course, is often the case for 13 and 14-year-old boys that have mental and emotional kind of retardation, if that's the right word, probably not anymore, but not the usual process of growth and maturation which you see in most young people. And these young people, as a result, are not considered by the judge and by the law to be as culpable as an adult making the decision to commit those crimes in the way that I described earlier, as a sort of sophisticated
But Chris, some would say, well, that makes them perhaps more dangerous. I mean, based on the fact that the judge is almost saying, well, you didn't know what you were doing. Your mental capacity is zero, and, you weren't in control of anything. You didn't understand that it was... I mean, that's a dangerous kid out there. And, custodial... I'm not suggesting you bury somebody in a ground in Wormwood Scrubs, but to be removed from the public for safety reasons would sound reasonable.
But what you've just said about the situation is not what the judge said. The judge didn't say any of those things. What the judge was doing, and I think people need to understand this, there's a choice to be made. And the law says that when you sentence a child, you must consider their welfare, education and rehabilitation as the primary considerations. That's what the law, the statutory law says. Now, all the judge has done is apply the law. Now, people don't like the law and they think, oh, actually, 13-year-olds should be treated exactly the same as 40-year-olds when they commit sex offences. Then fine, give them 20 years and they can go to prison for 20 years. But the problem with that, Ian, is there is an illusion that these things are a deterrent. So, for example, I was doing an interview about this yesterday, and someone said, well, how will these 13-year-olds know what to do and right from wrong if the judge says it's all okay? Well, that presumes that these 14-year-olds, like any potential criminal, are sitting around waiting for judges to pass sentence, read about them on the news, and then decide whether to go and do a crime or not. I mean, that's just not how crime works. It's certainly not how 13-year-olds think. And so the reality is we have to ask ourselves a question, and here's the bigger question, Ian. There are, on the latest figures, 800,000 people who were the victim of some form of sexual assault in 1 year. Only a few hundred people a year ever go to prison for rape or serious sexual assaults, a low number of thousands. So, in other words, 0.something% of all the examples of sexual assault result in someone going to prison. Now, of course, you can pick one headline case of 13 and 14-year-olds, which is at the serious end of the spectrum, and start to ask questions about it. But the real question is, what are we doing about the 800,000 victims who are getting no justice?
Well, I think on that point, we would also agree with that. Listen, this one will go on and we'll wait and see what happens at the Court of Appeal. Chris, thank you. Chris Dorr, KC, barrister, writer and broadcaster. The judge was just applying the law, says Chris. Your thoughts on that? 0344 499 1000.